Happy Friday, ladies and gentlemen. It is a beautiful day out there, and I just can't tell you how awesome it is for you to grace me with your presence. Your energy bounces off of me, and I bounce it off of others. And that's how it works. You are such an incredible being and force that I just want to tell you that there's a evil out there that wants that from you. How do you make somebody know that they're not special? How can I show you that you're not a God? How can I show you that you are not something incredibly awesome and have the ability to do anything you want if you put your mind to it? It's simple. I'll lock you up for something, or a government will lock you up, put you in a jail cell, test your wherewithal. And now you're no longer all of those things. They've removed you from you understanding that you're a God. Okay? John 10:34 says it clearly. Ye are gods and children of the Most High. Okay? So any one of you pastors arguing out there say, oh, you ain't no God. Stop. You are a God. That's how it is originally formed. People of high melanin in their skin created all the sciences, including spirituality, and they didn't get the chance to teach it to us before great evil destroyed their culture. They were called the people of Kemet. Anyway, you can get out of any contract. Okay, people tell me, oh, you can't get out of any contract. Well, excuse me. You can get out of a contract, not any contract. You can get out of a contract that's not binding, that's not under all the sections that it needs to be under law. So if there's no full disclosure, if they didn't bring equal consideration, et cetera, et cetera. Consideration is what of value did you bring to the table? So coming out of Corpus Juris Secundum 17b, contracts, proven to you that you can terminate a contract under those conditions. So here, okay, where a contract provides that it will continue for the stated period, it is not terminable at the option of either party, and where the contract has been fully performed by one party. It cannot be terminated by the other. Every contract is prima facie, means on its face, permanent and irrevocable, and it lies on the person who says that it is revocable or determinable to show either some expression in the contract itself or something in the nature of the contract for which it is reasonable to be implied that it was not intended to be permanent and irrevocable, but was to be in some way or the other subject to termination. Notwithstanding the foregoing rules, a party may cancel a contract without legal right and thereby subject itself to the recovery of damage by the other party. The party terminating the contract can defend the decision by reference to evidence not available to it at the time of termination, meaning that the party may terminate the cause and gamble that its estimates of the situation will be justified when all facts are proven. When all the facts are proven. However, a party is not entitled to terminate a contract under termination provisions which gives such party termination rights if the second party fails and refuses to comply with the terms. Where the second party fails to comply, comply is not in bad faith, but is based upon good faith dispute as to the amount due. As to the amount due. Okay? So there has to be equal consideration. When you go sign a car contract, when you sign a mortgage, when you sign a credit card, do they fully disclose the contract? What do they bring of consideration to the table? They don't bring anything. The country's bankrupt, bankruptcy. That's why the system of your courts can't make claims against you because they're bankrupt. Okay? They arrest us every day for writs of attachment. okay? And they write 4 bonds in our name. Once they get you and convict you, they lien your property, okay? Which is the social security number. Now, I'm going to be coming out of this book right here, okay? Ray D. Henson, document title under the Uniform Commercial Code, second edition, okay? This is a law expert this is an expert in law on the Uniform Commercial Code. Now, I want you to understand, when you take my course, this is not legal advice. You want legal advice? Go hire an attorney, okay? Attorneys are torn for the dead. You go hire them. There's a guardian ward relationship between you and them, okay? It's the same with the Social Security contract. Their guardian, your ward, and they're a discrete entity of the U.S. corporation, okay? The U.S. corporation is the same as Walmart and all those other companies. They're no different. What is their primary motive? To get money. I'm not against getting money. I'm against when they lie to us, okay? So we don't negotiate in my class, okay? We don't negotiate. I teach you that. I teach you how to resend the document, okay? Now, section sign 1302, attachments of security interest, okay? Listen, okay? It is possible to have a security interest in a document of title or in the goods covered by the document of title, as defined in section 1-201-37. A security interest means an interest in personal property or fixtures which secures payment or performance of an obligation. Now, when you go sign the contract for a mortgage, credit cards, or car loan, or any kind of loan, what was I going to say? I lost my my train of thought for a second. What they do is they bring you into court saying that you owe. With taxes, they'll lock you up. With a DUI, you didn't harm anybody. There's no corpus delicti. They'll lock you up. You know, they'll lock you up and throw you in jail. They'll put a lien on your property, write 4 bonds in your name, and they'll put a writ of attachment on you. A writ of attachment is a warrant for an arrest. Okay, an attachment is the seizing of your property, your body, your labor, your time. Okay, they get your body. Look at the statute merchant. Now, the Uniform Commercial Code back in the day was the law merchant. It was the law merchant. Okay, now that you understand what a writ is a judicial order, tell the judge to come and get you. Now, the attachment is the seizing of your body and your property. Anything associated to you is your property under law, including your freedom and time. Now, let me finish this. Okay? Fixtures, which secures payment or performance of an obligation, this interest will ordinarily arise by agreement and because the parties intended to create it. Usually, payment of an obligation is what is secured. Okay? Usually, payment of an obligation is what is secured. But occasionally, performance of an obligation will require security. Okay? As in the insurance of a surety bond. I told you they write 4 bonds in your name. A surety bond, a replevant bond, a performance bond, and a bid bond. All bonds are in your name. So they write a bond. Okay? A bond is a promise to pay or a promise to perform something in the future. Okay? Pay attention. Okay? Obligation. Okay. Usually payment of an obligation is what is secured, but occasionally performance of an obligation will require security, as in the assurance of a surety bond, when the insurer may be required to pledge of collateral in the event that the insurer is called upon to perform the underlying contract. For present purposes, when a security interest has been created, it is enforceable between the parties and has attached if the collateral has been pledged with the secured party under the agreement, which may be oral. That's why they get you to plead. Sir, how do you plead? Pleading guilty and not guilty are almost the same. Oh, you didn't know there was more than one way to plead, 2 ways to plead, or 3 ways to plead? There is. You can plead not assumption by way of confession and avoidance. You can plead mute. You can plead, there's several ways to plead. You can say, what happened to me being innocent or what happened to me being innocent? I don't let you know that, you see? So the collateral is your body. The collateral is your body, your future labor, your performance. They hold that in collateral, has been pledged. Collateral has been pledged with the secured party under the agreement, which may be oral, or if the debtor, which is you, has signed a security agreement. That's why I teach you, be careful how you sign, people. Be careful. 1, don't talk so much. 2, watch the way you sign. When you take my course, you learn how to sign your name. Okay? Security agreement is effective according to its terms between the parties against purchasers of the collateral and against the creditors. One place in which the code provides otherwise in section 9-301(1), in which an unperfected security interest is subordinate to the right of various third parties. That leads naturally to section 9-302(1), which states the general rule that filing is required for perfection of the security interest unless an exception is made. The principal exception are for collateral in the possession of the secured party under section 9-305 for security interest temporarily perfected in the instrument or document which without delivery under section 9-304 for the security interest of the collecting bank under section 4-208. The bench is a bank. The judge is sitting on a bench. That bench is the bank. Anybody arguing this with me, get your attorney, bring him over here and make him prove to me that this is not true and correct. But tell that attorney to go in court in front of a judge and in front of a prosecutor, sign. I'll sign an affidavit under the penalty of perjury accepting full commercial liability to what I'm saying is true and correct. Tell your public servants to do that. Tell your lawyer to do that. Make him sign what I'm saying. An affidavit under the penalty of perjury accepting full commercial liability. There's no lies. There's no law against lying. There's laws against perjury. Perjury. Okay. They won't do that in open court. If you're in court, ask this one question. If you ask anything, Your Honor, would you and the prosecutor be willing to sign an affidavit under the penalty of perjury accepting full commercial liability for what you're saying is true and correct to the letter of the law? So help you God. You have to raise your right hand, or you have to say, I swear to tell the truth, the whole truth, and nothing but the truth. So help me God. When do they do that? They see you do it, but you don't see them do it. Okay? That's what I want to see. Of course, they do it, but they pledge an oath to the Constitution. But they won't do that. Okay? So where was I? The principal exceptions are for the collateral in possession of the secured party under section 9-305 for security interest temporarily perfected in instruments or documents without delivery under section 9-304 for the security interest of the collecting bank under section 4-208 and for the security interest arising under Article 2 as referred to in section 9-113 when the secured interest has attached and the applicable steps for perfection have been taken, the security interest is perfected. It is, of course, possible that filing, if that is the applicable requirement for perfection, may be may have occurred before the necessary event of attachment have occurred, in which case the security interest becomes perfected on attachment. Okay? The security interest in negotiable documents may be perfected by filing or by taking possession of the document. When the perfection is by filing, the secured party runs the risk that the person in possession may duly negotiate it under section 7-501(4) to the holder and holder in due course. Look up those two words. Who will be entitled to priority over the early secured interest perfected by filing. Filing would, however, protect the secured party from claims subsequent lien creditors. That's them. That's the judge and these clowns, such as a trustee in bankruptcy. Your courts can't make claims against you because they're bankrupt. I just read it to you. I'm not going to read no more. For most purposes, perfection by the possession of the document would be essential to avoid priority problems arising from due negotiation of the document, and the distinction between priority and perfection may be consistently kept in mind. That, man, this is so full of information right here. People, wake up. Wake up. These people don't have you in their best interest. They don't. They're here to make money. I have a course that's 10 weeks long to 14 weeks long that will show you an in-mindset concept on the form of this process. I didn't invent this process. This process was created by somebody long before us. If anybody tells you that they've created this process, they're lying to you. Okay? This all the talent from doing all this was created hundreds of years ago, 100 years ago. Okay? These people don't have the mindset to create this kind of stuff. They don't. Okay? In this day, I'm talking about your judges and prosecutors and all that. I'm talking about them. Okay? Now that you go look this up for yourself. This is not legal advice. You want legal advice? Go hire an attorney. I don't know how to hire an attorney. You need to find out and figure out what's best for you. Okay? Now that I've proven that to you, I want to just tell you and thank you for gracing me with your presence. It's really been a great day to have you on this earth. Okay? Now, remember, those who expect to be both ignorant and free expect for something that never was and never will be. That was Thomas Jefferson. Okay? Have a good day. Don't drink and drive. Don't give these people a reason to attach a lien to your property. Okay? You are wonderful. You are great. Don't let anybody convince you of otherwise. Have a good day.